Srimati Akshata AP to escort the resource persons to the stage for the concluding session. May I ask Sir K.G. Johnson, Deputy Labour Commissioner, Bangalore, Shri Prashant B.K., Advocate of High Court of Karnataka and CCI Legal from Bangalore, Dr. Rashmi Shetty, NL, SIU, Bangalore, and Dr. B.K. Ravindra, Director of Legal Studies, and also Dr. Babu Matthew, Professor Emeritus, Dr. Rashmi Shetty, NL, SIU, Bangalore. Before we begin the interaction, I request Shri Prashant B.K., Advocate of High Court of Karnataka, Bangalore, CCI Legal Firm, to address on the topic enforcement of labor codes and other dimensions. Mr. Prashant B.K. is an advocate and management consultant practicing in the name of CCI Legal Firm, having principal office at Bangalore along with branch offices at Mangalore and Mysore. He is a postgraduate in Law and Human Resources Management. Before venturing into legal practice, he was associated with prestigious companies such as Bharat Electronics, Isular India, and Aditya Birla Group. Mr. Prashant specializes in labor and industrial laws. That apart, he also practices service matters, commercial and arbitration disputes. He practices mainly in the High Court of Karnataka, Industrial Tribunal and Labor Courts, Commercial Courts and City Civil and Session Courts at Bangalore, and occasionally before the Honorable Supreme Court as well. Now I invite Shri Prashant B.K. to speak on the topic enforcement of labor codes and other dimensions. Over to you, sir.
Good afternoon. No voice. Good afternoon. I have come all the way from Bangalore now, and I am eager to hear louder noise. All youngsters sitting here, it makes my job slightly difficult. Always talking to practitioners who knows industrial law, that is slightly easy. Rather talking to, I think all of you are studying now labor and industrial laws. That is also after hearing Professor Babu Matthew. Now I am a management advocate. My union friends are sitting here. So probably you may hear something different perspective. But rather as a management advocate, I would like to talk upon what is this code, what government has done right, probably what are the challenges we are going to have in enforcement of these labor codes. In fact, now wherever we go, maybe Puttur ali gottilla, but whichever big cities, all are busy with having so many conferences about new codes. Yesterday we also had a one-day workshop, and we had more than 350 delegates across the industry. So that is the essence of the matter. Since all of a sudden government has notified, now all industries, workers, management, etc., everybody should need to go into the implementation of these codes. I am sure some of the aspects what I talk would be repetitive. In industrial law in India, largely has been, often it has been told that laws are obsolete, laws are required to be changed, investors are not coming. Today we are competing on global scale. So India, the dream of government of India is to make India as a manufacturing hub. So investments when coming from other country, often we used to hear too many compliances, too many returns. Each and every act you have to make 3-4 returns. And if you, for some reasons, if you don't do, straight away, my friend from Labor Department is here, straight away you prosecute. Labor inspector will come. He will come with the standard template, and he will issue on show cause notice. You reply, he will go and file a prosecution straight away before magistrate. For example, payment of bonus act. You have paid bonus. Unfortunately, you are a small player. You don't know how to maintain the record. Labor inspector comes, he gives one show cause notice, and whether you replied or not, he goes and files one complaint. Prosecution, you get a summons from magistrate. Many times employers were asking, sir, beka sir, business madbeka. So many times we went to High Court, so many times we get them quashed. Again one inspector goes, again files one particular petition. So, particularly keeping all these aspects, I think the Government of India came out with these codes. But what has happened? Codes were drafted in the year 2020. Thereafter, government took 5 years' time. I think the government would have done little better insofar as what they have done 5 years back before notifying these acts. For example, don't take me wrong, I am not criticizing government, but every work there is a scope for improvement. For example, when you look at most of the provisions, if you look at, there is a reference to CRPC, there is a reference to IPC, there is a reference to Indian Evidence Act. All these acts are ceased to exist because originally in the year 2020 all these 3 acts were there. But thereafter when you see now those 3 acts are not there. You know very well, law students know very well, all of them have been replaced. So, but particularly before notifying, government has not seen that. Now, for example, CRPC has to be replaced by BNSS. That is missing there. One example. One more example, since I'm given with the limited time, since IR code, Mr. Matthew has spoken in detail, one of the complaint my friends are having is that we don't have the forum to adjudicate. I will give you a small example. Now the new code, it says you need to have a industrial tribunal having along with the bench of 2 persons, 2 officers. One presiding officer is judicial officer. On top of that, you would be having one administrative officer. Together they have to, that is the quorum. Now, workmen will ask, first of all, labor court and tribunal, you are taking 3 years, minimum 3 years or 4 years or 5 years. Now you are giving a forum having 2 persons. For example, now I am the judicial member, Mr. X is the administrative member. For me, discipline is non-compromisable. A dismissal case comes to the quorum. I say that discipline is not at all compromisable, which is foundation for survival of the organization. I say that no sympathy. Whereas another person says, no, it's all right, we'll give them a chance. Because industrial law is always a judge-made law. Earlier Industrial Dispute Act, we had less than 50 sections. 50 section ಗಿಂತ ಕಮ್ಮಿ ಇದ್ದ ಕಾಯ್ದೆ Industrial Dispute Act. But a few millions of cases, judgments have been reported in industrial law. So therefore, now ಏನಾಗುತ್ತೆ, judicial member will say something. For him, dismissal is justified. For administrative member or vice versa. For administrative member, dismissal is not justified. So there is no consensus between 2 members. So now what happens is, whatever split award opinion, it has to be tabled before appropriate government. Now government has to refer it to another judicial member of another tribunal. Now for example, look at Mangalore. You have one labor court in Mangalore. Now labor court will cease to exist. Let's say you are having industrial tribunal. Now there are 2 members. Administrative member ಹೇಳ್ತಾರೆ in the favor of management. Judicial member ಹೇಳ್ತಾರೆ in favor of workmen or union. Now it has to go to government. Government has to refer it to presiding officer of judicial member of another tribunal. First of all, now we are taking 3 or 4 years. Now for some example, administrative member gets retired or judicial member gets retired. What is the fate of the workmen? Management, I am a management lawyer, but still I find a genuine problem when workers speak about this particular, or union when they talk about this particular issue. Now justice delayed is justice denied. Now instead of 3 years, if you take 7 years or 8 years or 10 years, or which member you are referring. For example, you are in Mangalore. Let's say you refer it to a judicial member from Mysore. Whether union or workmen at Mangalore, whether they can afford sending an advocate to argue before that of member, these are the practical issues need to be considered. Since I am talking on implementation, what are the difficulties I am trying to identify? See, one of the aspects is, second problem is that the constitution of industrial tribunal, it has to be done in accordance with Finance Act 2017. Under section 184 of this Finance Act, Government of India has been given with the powers to frame rules with respect to appointment of presiding officers of tribunals. Now Justice Ranjan Gogoi bench has already quashed that rule, those rules. Now rules illa antadre neen hege constitute court and hege marti? Now section 51 says, whatever cases that are pending before in labor court and tribunal, they are deemed to be the proceedings pending before the code. It has to continue as it is. It has to be transferred to tribunal under the code. Now tribunal is not there. What would be the fate of these ongoing disputes? These are the practical challenges. Already our workmen or worker or union friends already have filed on writ petition in Delhi High Court. Delhi High Court noticed that aspect. They have issued notice to Government of India. One interesting thing what Government of India done, they have kept themselves 3 years time. Whatever difficulties you get in implementation, they have the powers to pass administrative orders and they can table it before the Parliament. So immediately now what Government of India, they have also noticed that vacuum. Now Government of India has said, whatever labor courts or tribunals existing under Industrial Disputes Act will continue to function till it is normally till industrial tribunals are constituted under the code. That is point number one. Now next question is, now the Labour Commissioner is sitting here. Next challenge, now order of reference. Now what happens is, if there is any dispute, you have to conciliate the matter other than termination related matters. Any industrial dispute. What is industrial dispute? Anybody can tell me here? What is industrial dispute? ಕೈಗಾರಿಕಾ ವಿವಾದ ಅಂತ ಹೇಳಿದ್ರೇನು? ಯಾರಿಗೆ ಗೊತ್ತಿದೆಯಾ? So industrial dispute, normally it is a collective dispute, to put it in the most simplest manner rather than talking as a jurist. It has to be collective dispute between workmen and employer. I will confine it today only for that. Or else in case of terminations, individual disputes also deemed as industrial disputes. ಇವಾಗಿರುವ ಕರೆಂಟ್ ಸಿಸ್ಟಮಲ್ಲಿ ಇಂಡಿವಿಜುವಲ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಯಾವಾಗ ಯಾರನ್ನಾದರೂ ಟರ್ಮಿನೇಟ್ ಮಾಡಿದರೆ ಯು ಕ್ಯಾನ್ ಸ್ಟ್ರೈಟ್ ಅವೇ ಅಪ್ರೋಚ್ ಲೇಬರ್ ಕೋರ್ಟ್. In all other matters you have to go to conciliation officer. Matter has to be conciliated. Either in conciliation arrive at a settlement. If settlement is not done, refer the failure report to government, and government used to make the reference. All of your union friends, all of you are aware. Now as per the new code, this reference system is ceased to exist. ಸರ್ಕಾರಕ್ಕೆ ರೆಫರೆನ್ಸ್ ಮಾಡುವ ತಲೆಬಿಸಿ ಇಲ್ಲ. ಕನ್ಸಿಲೇಷನ್ ಮಾಡಿ ಆದಮೇಲೆ ಕನ್ಸಿಲೇಷನ್ ಫೇಲ್ ಆದರೆ ಎಗ್ರೀವ್ಡ್ ಪಾರ್ಟಿ, ವರ್ಕರ್ ಇರ್ಬೋದು, ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಇರ್ಬೋದು, ಡೈರೆಕ್ಟ್ ಆಗಿ ದೇ ಕ್ಯಾನ್ ಗೋ ಟು ಇಂಡಸ್ಟ್ರಿಯಲ್ ಟ್ರೈಬ್ಯುನಲ್ by filing a application. Now question is, now labor court and tribunal will continue. That is what notification of Government of India says. Now question, now government has to decide whether they can do order of reference now. Now order of reference is ceased to exist. ಇರುವ ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಕಾಯ್ದೆ ಪ್ರಕಾರ, ಅದರ್ ದೆನ್ ಟರ್ಮಿನೇಷನ್ ಕೇಸಸ್, ಆಲ್ ದ ಕೇಸಸ್ ಆರ್ ಹ್ಯಾವಿಂಗ್ ಫೌಂಡೇಶನ್ ಇನ್ ರೆಫರೆನ್ಸ್. Government has to make points of reference. Based on the reference, points of reference, tribunal or labor court used to adjudicate. ಇವಾಗ ರೆಫರೆನ್ಸ್ ಸಿಸ್ಟಮ್ ಇಲ್ಲ as per the new code. Now question ಬರ್ತದೆ, unions will go and ask the officers whether you do the reference or not. Now presiding officers are thinking, if somebody approaches directly, whether we can take that matter or not. Because these are the challenges Government of India has to address in coming days. I am not blaming Government of India. I appreciate Government of India. Whatever our union friends, let them yell at these legislations, it was need of the hour. But I, with the sense of responsibility, I say there is still work in progress. ಇದನ್ನೆಲ್ಲ ವರ್ಕ್ ಮಾಡಿ ಇಂಪ್ಲಿಮೆಂಟ್ ಮಾಡಿದ್ದಿದ್ರೆ ಸ್ವಲ್ಪ ಕನ್ಸರ್ನ್ಡ್ ಪಾರ್ಟೀಸ್ಗಳಿಗೆ ಈಸಿ ಆಗ್ತಾ ಇತ್ತು. ಇವಾಗ ಯಾರೋ ಒಬ್ಬ ಬ್ರಹ್ಮ ಬರೆದಿದ್ದಾನೆ, ಎಕ್ಸಿಕ್ಯೂಟಿವ್ ವೇಜ್ ಅಂತ ಒಂದು ಡಿಫೈನ್ ಮಾಡಿದ್ದಾನೆ. ಎಸ್ಟರ್ಡೇ ವಿ ಸ್ಪೆಂಡ್ 2 hours. Very, very difficult to understand the concept of wages under new act, under the Wages Act, Wages Code. It says 50%, whatever exclusion categories, it should not be more than 50%. I am not telling that net take home comes down, no problem. I tell you before that, our union friends say that net take homes comes down. It is a false claim. Same union friends used to tell me, employers are giving only 30% of the gross salary as basic. Only 35% salary as gross basic. ಇನ್ನು ಕೆಲವರು ಹೇಳ್ತಾ ಇದ್ರು ಬರೀ 25% ಕೊಡ್ತಾರೆ, ಬೇಸಿಕ್ ಕಮ್ಮಿ ಕೊಡ್ತಾರೆ, ಸೊ ನಮಗೆ ಗ್ರಾಚ್ಯುಟಿ ಸಿಗಲ್ಲ, ನಮಗೆ ಬೋನಸ್ ಸಿಗಲ್ಲ, EPF ಅಕ್ಯುಮುಲೇಷನ್ ಕಮ್ಮಿ ಆಗುತ್ತೆ ಅಂತ ನಮ್ಮ ಸೇಮ್ ಯೂನಿಯನ್ ಸ್ನೇಹಿತರು ಹೇಳ್ತಾ ಇದ್ರು. ಅದಕ್ಕೋಸ್ಕರ ಸರ್ಕಾರ ಏನು ಮಾಡಿದೆ, ಮಿನಿಮಮ್ 50% ಬೇಸ್ ಸ್ಯಾಲ್ರಿ ಅಂತ ತಗೊಳ್ಳಿ ಅಂತ ಹೇಳ್ತಾರೆ. ಸೊ ನೆಟ್ ಟೇಕ್ ಹೋಮ್ ಹೋದರೂ ಸಹ ಟುಡೇ ಇಟ್ ಗೋಸ್ ಮೋರ್ ಕಾಂಟ್ರಿಬ್ಯೂಷನ್ ಟು EPF. ಯು ಹ್ಯಾವ್ ವೆರಿ ಹ್ಯಾಂಡ್ಸಮ್ ಇಂಟ್ರೆಸ್ಟ್ ಆ್ಯಂಡ್ ನೌ ವೆರಿ ವೆರಿ ಲಿಬರ್ಟಿ ಇಸ್ ದೇರ್. ಎನಿ ಟೈಮ್ ಯು ಕ್ಯಾನ್ ಗೋ ಆ್ಯಂಡ್ ಟೇಕ್ ಯುವರ್ ಮನಿ ಫ್ರಮ್ EPF ಡಿಪಾರ್ಟ್ಮೆಂಟ್. ಬೋನಸ್ ಗೋಸ್ ಅಪ್, ಗ್ರಾಚ್ಯುಟಿ ಗೋಸ್ ಅಪ್. ಸೊ ದೇ ವಿಲ್ ಸೇ ಇಲ್ಲ ರಿಟ್ರೆಂಚ್ಮೆಂಟ್ ಕಂಪನ್ಸೇಷನ್ ಕಮ್ಮಿ ಆಗುತ್ತೆ. ರಿಟ್ರೆಂಚ್ಮೆಂಟ್ ಯಾವಾಗ ಕಮ್ಮಿ ಆಗೋದು? ರಿಟ್ರೆಂಚ್ಮೆಂಟ್ ಮಾಡಿದರೆ, ಫ್ಯಾಕ್ಟ್ರಿ ಕ್ಲೋಸ್ ಮಾಡುವ ಸಂದರ್ಭದಲ್ಲಿ ಅಥವಾ ರಿಟ್ರೆಂಚ್ ಮಾಡೋ ಪರಿಸ್ಥಿತಿ ಬಂದರೆ ಅದು ಬರೋದು, ಇಲ್ಲ ಬರೋದೇ ಇಲ್ಲ ಅದು. ಕ್ವಶನ್ ನೆಟ್ ಟೇಕ್ ಹೋಮ್ ಇದಲ್ಲ ಕ್ವಶನ್ ಇರೋದು ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಆಫ್ ವೇಜಸ್. ಈ ಎಕ್ಸ್ಕ್ಲೂಷನ್ ಕ್ಯಾಟಗರಿಯಲ್ಲಿ ಓವರ್ ಟೈಮ್ ಅಂತ ಹಾಕಿದ್ದಾರೆ. ಓವರ್ ಟೈಮ್ ಫ್ಲಕ್ಚುಯೇಟ್ ಆದರೆ ನಿಮ್ಮ ವೇಜು ಸಹ ಈಗ ಬೇಸ್ ಅಂತ ಹೇಳೋಕ್ಕಿಲ್ಲ, ಓನ್ಲಿ ವೇಜಸ್ ಅವ್ರ ಸ್ಯಾಲರಿ. ಮೊಮೆಂಟ್ ಓವರ್ ಟೈಮ್ ಜಾಸ್ತಿ ಆದರೆ ನಿಮ್ಮ ಏನು ವೇಜಸ್ ಸ್ಯಾಲರಿ ಏನಿದೆ ಅದು ನೀವು 50% ಎಕ್ಸ್ಕ್ಲೂಷನ್ ಅನ್ನು ಲಿಮಿಟ್ ಮಾಡಿದಾಗ ಬೇಸ್ ಸ್ಯಾಲರಿ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಸೊ ನಿಮಗೆ ನಾಳೆ ಈ ತಿಂಗಳಿಗೆ ಒಂದು ಸಂಬಳ ಇದ್ದರೆ ನೆಕ್ಸ್ಟ್ ತಿಂಗಳಿಗೆ ಇನ್ನೊಂದು ಸಂಬಳ ಇರುತ್ತೆ. So overtime, all of you are aware, overtime cannot be part of that is additional earning. For example, commission ಅನ್ನು ಸೇರಿಸಿದ್ದಾರೆ. Commission in sales field, somebody goes to field and they sell it, they get sales commission. Sales commission, something is extra from gross. That cannot be part of your fixed wages, but ಅದನ್ನು ತಂದಿದ್ದಾರೆ. So therefore, wages, employers are having serious problems how to fix wages in accordance with the wage code. Please note this. This is not the union's problem. Now problem, every employer is coming and asking us, sir, how can we interpret this? Then a lighter note I said, we have to interpret by only filing few writ petitions. Let them come and explain how. Because now commission. Now I will give you one more example. Now you are a salesperson, or let me talk from factory. Puttur has got some factories. Attendance bonus anta kodtare. If you are working, if you are giving 100% attendance is there to encourage you discipline, punctuality, some attendance bonus they give. It is fluctuating. How can it be part of your gross salary? Similarly, shift allowance anta kodtare. Some of the workers come during the night shift. You give them something special. Shift allowance can be part of the wages. ಅವ್ರು ಬರೋರಿಗೆ ಮಾತ್ರ ಕೊಡ್ತಾರೆ. That should be extra. It is not the contract. It is not part of your contract. These are the practical difficulties for HR people to define their wages. They have attempted to follow Central Civil Service rules, but in the context they have lost the track. But purpose, intention has been good because there are some employers who are not paying basic wages properly. So that whatever consequential benefits what workmen were getting, that were coming down. So intention of the government has been pretty good there. So that definition of the wages is one aspect need to be seen. In Payment of Bonus Act, there is no difference at all. Minimum wages, now skill-based, earlier industry-based minimum wages used to be there. Now it would be based on the skill or geography, or skill and geography. For example, municipal cities, municipal corporations, rural areas, etc. The three categories they have indicated where government is empowered to fix the minimum wages. Again, I have seen my union friends are scolding about national floor wages. There is nothing to blame. National floor wages says you should not give minimum wages less than this. Who stops you from giving more? ನ್ಯಾಷನಲ್ ಫ್ಲೋರ್ ವೇಜಸ್ ಅನ್ನು ಕೇಂದ್ರ ಸರ್ಕಾರ ಫಿಕ್ಸ್ ಮಾಡುತ್ತೆ. ಸ್ಟೇಟ್ ಗೌರ್ಮೆಂಟ್ಸ್ಗಳಿಗೆ ಕಂಪ್ಲೀಟ್ ಎಂಪವರ್ಮೆಂಟ್ ಇದೆ ಅದಕ್ಕಿಂತ ಜಾಸ್ತಿ ಕೊಡೋದಕ್ಕೆ. ಹಾಗಾಗಿ ನ್ಯಾಷನಲ್ ಫ್ಲೋರ್ ವೇಜಸ್ ಯಾವ ರೀತಿಯಲ್ಲೂ ಸಹ ಇಂಪ್ಯಾಕ್ಟ್ ಮಾಡೋದಿಲ್ಲ. ಈಗ ಪ್ರಾಕ್ಟಿಕಲ್ ಎನ್ಫೋರ್ಸ್ಮೆಂಟ್ ಇರೋದು ಒಂದು ಬಂದು ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ಫ್ರಮ್ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಆ್ಯಕ್ಟಲ್ಲಿ ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ಎಡ್ಜುಡಿಕೇಷನ್. ಐ ಫರ್ಮ್ಲಿ ಬಿಲೀವ್ ವರ್ಕರ್ ಇಫ್ ಈಸ್ ಹ್ಯಾವಿಂಗ್ ಎ ಗ್ರೀವಿಯನ್ಸ್, ಆ ಗ್ರೀವಿಯನ್ಸನ್ನು ಆದರೆ ಎಂಪ್ಲಾಯರ್ ಸಾರ್ಟ್ ಔಟ್ ಮಾಡಬೇಕು. If not employer at the level of conciliation officer. If not, it has to be adjudicated at the earliest. Because if there is a grievance which is not settled, and if there is no forum to settle the grievance, it will only make workmen frustrated. Frustrated workmen will not give the productivity. At the end of the day, it is neither it benefits employer nor it benefits government or workers. Therefore, adjudication mechanism, I think government needs to look at, and probably they have to come out with some structural changes. Next important aspect, I am sure already somebody would have spoken, is about standing orders. Standing orders ಬಗ್ಗೆ ಮಾತಾಡಿದಾರಾ? ಇಲ್ಲ. Now standing orders is one of the area where again our union friends have a reason to get upset. They have a genuine reason to get upset. It also requires a little bit of modification according to me. Now standing order chapter 4, it says it is applicable to only 300 workers and more. 300 ಜನಕ್ಕಿಂತ ಜಾಸ್ತಿ ಇರೋರಿಗೆ ಮಾತ್ರ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಆರ್ಡರ್ಸ್ ಅಪ್ಲೈ ಆಗುತ್ತೆ. ಅವರು ಡ್ರಾಫ್ಟ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಆರ್ಡರ್ಸ್ ಸಬ್ಮಿಟ್ ಮಾಡಬೇಕು. ಸಪೋಸ್ 300ಗಿಂತ ಕಮ್ಮಿ ಇದ್ದರೆ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಚಾಪ್ಟರೇ ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ. ಸೊ ಹಾಗಾದರೆ ಮಾಡಲ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಆರ್ಡರ್ಸ್ ಅಪ್ಲೈ ಆಗೋದಿಲ್ಲ. ಸೊ ಅಗೇನ್ ದೆನ್ ಹೌ ಯು ಡಿಫೈನ್ ಟರ್ಮ್ಸ್ ಆ್ಯಂಡ್ ಕಂಡೀಷನ್ಸ್? ಯು ಹ್ಯಾವ್ ಟು ಪುಟ್ ಎವ್ರಿಥಿಂಗ್ ಇನ್ ಅಪಾಯಿಂಟ್ಮೆಂಟ್ ಲೆಟರ್. Your appointment letter should contain everything whatever normally we used to have in standing orders. For example, retirement age. ರಿಟೈರ್ಮೆಂಟ್ ಏಜು ಕರ್ನಾಟಕದಲ್ಲಿ 58 ಇತ್ತು. ಅದನ್ನು ಸುಮಾರು 2016ರಲ್ಲಿ 60 ಮಾಡಿದರು. ಇನ್ನು ರೂಲ್ಸಲ್ಲಿ ಅದು ಆಟೋಮೆಟಿಕ್ ಅಲ್ಲ, ಅದರ ಬೇಸಿಸ್ನಲ್ಲಿ ಹೋಗಿಬಿಟ್ಟು ಯೂನಿಯನ್ಸ್ ಎಂಪ್ಲಾಯರ್ಸ್ ಹೋಗಿಬಿಟ್ಟು ಸರ್ಟಿಫಿಕೇಷನ್ ಮಾಡ್ತಾಯಿದ್ರು. ದೇ ವರ್ ಗೆಟಿಂಗ್ ಇಟ್ ಸರ್ಟಿಫೈಡ್ ಫಾರ್ 60 years. Enhanced ages. Now there is no provision only. That provision will cease to exist. Now workmen will ask, what is my retirement age? It cannot be at the whims of the employer, end of the day. So therefore all these aspects, standing orders probably that 300, either employers should be given opportunity to have the standing orders even if it is less than 300. Because I believe standing orders is very useful to employer also. Many times I hear employers are telling, sir, standing orders. I often tell them, have standing orders. Define your terms. Your workmen should know, workers should know what are the terms and conditions of employment. So ivaga adu 300 threshold ಮಾಡಿರೋದು, probably that is another issue. Probably one of the issues unions may likely to raise a dispute. Barring, according to me, barring these wages, barring dispute mechanism, barring standing orders, rest of the aspects I appreciate. Lot of positive measures, Canteen has been reduced to 100. Earlier it was 250. Now if you are having more than 100, you have 100 employees, you have to give canteen. Welfare officers has come down from 500 to 250. Safety officers have come down from 1000 to 500. Ella employees ige benefit ಆಗ್ತಾ ಇದೆ. Mandatory health checkup. If you are having more than, if there are employees with more than 40 years, every year mandatory health checkup. Again, positive sign. So a lot of positive aspects are there for employees and also for employers. The returns have come down, compliance have come down, compounding of offense. See the prosecution hakakke barodilla. Government has to appoint an officer. He should hear the parties. 50% ಫೈನ್ ಮಾಡಿಕೊಟ್ಟು ಅವರಿಗಿರುವ ಅಫೆನ್ಸನ್ನು ಕಂಪೌಂಡ್ ಮಾಡ್ಬೋದು. ಎಲ್ಲ ಯಾವುದೋ ಒಂದು ಪಿಂಚ್ ಮಾಡಿದ್ದಕ್ಕೆ ಹೋಗ್ಬಿಟ್ಟು ಮ್ಯಾಜಿಸ್ಟ್ರೇಟ್ ಹತ್ರ ನಿಲ್ಲುವ ಅಗತ್ಯ ಎಂಪ್ಲಾಯರಿಗೆ ಇರೋದಿಲ್ಲ. ದಟ್ ಈಸ್ ದ ಬಿಗ್ಗೆಸ್ಟ್ ಬೆನಿಫಿಟ್. ಎಂಪ್ಲಾಯರ್ ರೈಟ್ಲಿ ಶುಡ್ ಹ್ಯಾವ್ ಇಟ್. ಆ್ಯಂಡ್ ದ್ಯಾಟ್ ಅಪರ್ಚುನಿಟಿ, ದಿಸ್ ಲಾಸ್ ಆರ್ ಕ್ರಿಯೇಟಿಂಗ್ ದ್ಯಾಟ್ ಅಪರ್ಚುನಿಟಿ ಫಾರ್ ಎಂಪ್ಲಾಯರ್ಸ್ ಆಲ್ಸೋ. ಆ್ಯಂಡ್ ಫಾರ್ ಆಫೀಸರ್ಸ್ ಆಲ್ಸೋ. ಇಫ್ ಯು ಲುಕ್ ಎಟ್ ಎ ಸೀರಿಯಸ್ ಆಫೀಸರ್, he can do everything through online. Your inspections, there is a electronic scheme, electronic inspection scheme. There is a provision. You can submit all your documents either through manual or through electronic form. That has been also recognized. Contract Labor Act, core area, it defines core area. I don't know how it will play. ಇವಾಗೆಲ್ಲ ಯೂನಿಯನ್ಸ್ ಹೇಳ್ತಾರೆ ಕಾಂಟ್ರಾಕ್ಟರ್ ವರ್ಕರ್ಸ್ ಜಾಸ್ತಿ ಎಂಗೇಜ್ ಮಾಡ್ತಾರೆ. ಇವಾಗ ಹೊಸ ಕೋಡ್ ಹೇಳ್ತಾ ಇದೆ, ಎಂಗೇಜ್ಮೆಂಟ್ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್ ವರ್ಕರ್ಸ್ ಇನ್ ಕೋರ್ ಏರಿಯಾಸ್ ಆರ್ ಪ್ರೊಹಿಬಿಟೆಡ್. ಕೋರ್ ಏರಿಯಾ ಏನು ಅಂತ ಡಿಫೈನ್ ಮಾಡ್ತಾರೆ. ಅಫ್ಕೋರ್ಸ್ ಅದರಲ್ಲಿ ಕೆಲವು ಎಸ್ಕೇಪ್ ರೂಟ್ ಸಹ ಕೊಟ್ಟಿದ್ದಾರೆ ಎಂಪ್ಲಾಯರ್ಸ್ಗಳಿಗೆ. ಬಟ್ ಇಟ್ ಈಸ್ ಎ ಕ್ವಶನ್ ಆಫ್ ಇಂಟರ್ಪ್ರಿಟೇಷನ್ ಹೌ ವರ್ಕರ್ಸ್, ಎಂಪ್ಲಾಯರ್ಸ್ ಆ್ಯಂಡ್ ಗವರ್ಮೆಂಟ್ ವಿಲ್ ಡಿಸೈಡ್. ಬಟ್ ಬೈ ಆ್ಯಂಡ್ ಲಾರ್ಜ್ ಎಂಗೇಜ್ಮೆಂಟ್ ಆಫ್ ಕಾಂಟ್ರಾಕ್ಟ್ ವರ್ಕರ್ಸ್, ಲೀಗಲಿ ಸ್ಪೀಕಿಂಗ್, ಪ್ಲೈನ್ ಸ್ಪೀಕಿಂಗ್, ಇಟ್ ಈಸ್ ಪ್ರೊಹಿಬಿಟೆಡ್. Now I will come to trade union registration matters. See, if you are forming a company, in India, if you are forming a company, we have many compliances. If you are having a cooperative society, you had lot of compliances. One area where everything was scot-free was unions. Believe me, don't take me wrong, I'm not generalizing at all. But there are number of unions. Between rivalry of the unions, we have seen so many allegations about richness of the union leaders. No returns at all, no audit at all. So no affidavit was required at all. So no, trade unions cannot say that no, we need not be regulated. Trade unions should say that we also need to be regulated. We have to be regulated, and what is required, we'll do the needful. If audit is required, we'll do the audit. If there is a resolution is required to be given, we'll give the resolution. Affidavit is required, we'll give the affidavit. Earlier there was no affidavit at all. So now trade unions. One more complaint from unions is that only 33% can be in organized industry, only 33% of the office bearers can be outsiders. Rightly so. We cannot deal with the trade union of outsiders. Trade union should be connected with the workers of that establishment. ಇಲ್ಲ ಅಂತಾದರೆ ಯೂನಿಯನಿಗೆ ಸಹ ಆ ಫ್ಯಾಕ್ಟ್ರಿ ಬಗ್ಗೆ, ಆ ಇಂಡಸ್ಟ್ರಿಗೆ ಬಗ್ಗೆ ಗೊತ್ತಿರೋದಿಲ್ಲ. ಯೂನಿಯನ್ ಶುಡ್ ನೋ ವಾಟ್ ಆರ್ ದಿ ಚಾಲೆಂಜಸ್ ಆರ್ ವಾಟ್ ಆರ್ ದಿ ರಿಕ್ವೈರ್ಮೆಂಟ್ಸ್, ವಾಟ್ ಆರ್ ದಿ ಪ್ಲಸ್ ಮೈನಸ್ ಆಫ್ ದೋಸ್ ವರ್ಕರ್ಸ್. ಇಫ್ ಎವ್ರಿಬಡಿ ಆರ್ ಸ್ಟ್ರೇಂಜರ್ಸ್, how a union can represent the causes of the workers. Union can represent the causes of the workers if there is a good nexus between union and workers. So therefore, in my opinion, rightly only 33%. Still 33% opportunity is there. Still ಒಂದು ಯೂನಿಯನ್ನಲ್ಲಿ 10 ಜನ ಇದ್ದರೆ 3 ಜನ ಔಟ್ಸೈಡರ್ಸ್ ಇರ್ಬೋದು. 7 ಜನ should be part of that union. I don't see any difficulties. I think union should welcome that particular measure. Rather complaining about that measure, union should welcome. According to me, Government of India has done the right thing. Now another thing is that they say that once you register, 7 members can go and register a union. And 10% should be from that industry. And now it says 10% should be continued forever. ಒಂದು ಸಲ ಯೂನಿಯನ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿ ಆದಮೇಲೆ 3-4 ವರ್ಷ ಆದಮೇಲೆ ಏನಾಗುತ್ತೆ, ಕೆಲವು ಸಲ ಆ ಯೂನಿಯನ್ನಲ್ಲಿ ಯಾರೂ ಇರಲ್ಲ. ಆ ಯೂನಿಯನ್ನಲ್ಲಿ ಅವರು ಯೂನಿಯನ್ ಬಿಟ್ಟು ಇನ್ನೊಂದು ಯೂನಿಯನ್ಗೆ ಹೋಗಿರ್ತಾರೆ. ಆ ಯೂನಿಯನನ್ನು ಮುಚ್ಚಬೇಕಾ ಬೇಡವಾ? ಆ ಯೂನಿಯನ್ನಲ್ಲಿ ಯಾರು ಇಲ್ಲ ಅಂತಾದ್ಮೇಲೆ ಆ ಯೂನಿಯನ್ ಯಾಕೆ ಇಟ್ಕೊಳ್ಬೇಕು? Unless you have that 10% members or workers are there in union, that union should not continue. According to me, not 10%, it should have been 25% or 20%. Otherwise, ಇದು ಏನಾಗುತ್ತೆ, ಅದನ್ನು ಮಿಸ್ಯೂಸೇ ಮಾಡ್ತಾರೆ. So therefore, in my opinion, that is also, now union should be very, very happy. They should be very happy. I see I have read some of the books, what is wrong in labor courts. Some my advocate friends from unions have gifted me that book. First thing I went and that night meticulously read the whole book. I found 30% genuine, 70% are cooked up. For example, negotiating, earlier Karnataka there was no requirement for recognizing a union. Only in the state of Maharashtra and Madhya Pradesh, you are legally required to recognize the union. ನೀವು ಯೂನಿಯನ್ ಫಾರ್ಮ್ ಮಾಡ್ತೀರಿ, ನಾವು ಮಾತಾಡೋದೇ ಇಲ್ಲ ನಿಮ್ಮ ಹತ್ರ. ಭಾಳ ಜನ ಬಂದು ನನ್ನ ಹತ್ರ ಕೇಳ್ತಾರೆ, ಸರ್ ರೆಕಗ್ನಿಷನ್ ಹೇಳಿದ್ರಿ ಏನು ಕರ್ನಾಟಕದಲ್ಲಿ ಅಂತ ಕೇಳ್ತಾ ಇದ್ರು. ನಾನು ಹೇಳ್ತಾ ಇದ್ದೆ, ನೀವು ಅವ್ರ ಹತ್ರ ಮಾತಾಡಿ ಏನಾದರೂ ನೀವು ಒಡಂಬಡಿಕೆ ಸೈನ್ ಮಾಡಿದರೆ ನೀವು ರೆಕಗ್ನೈಸ್ ಮಾಡಿದ್ದೀರಿ, ಇಲ್ಲ ಬರೀ ಮಾತಾಡಿ ಕಾಫಿ ಕೊಟ್ಟು ಕಳಿಸಿದರೆ ರೆಕಗ್ನಿಷನ್ಗೆ ಮಾನ್ಯತೆ ಕಾನೂನಲ್ಲಿ ಯಾವ ಮೀನಿಂಗು ಇಲ್ಲ ಅಂತ. ನೌ ಇಟ್ ಈಸ್ ನಾಟ್ ದ್ಯಾಟ್. Now employer has to recognize if you are a majority union. That also central rule says only 30%. 30% of workers are members of your union. I have to recognize that union. I have to negotiating union. ನಾನು ಅವ್ರ ಜೊತೆ ನೆಗೋಷಿಯೇಟ್ ಮಾಡಲೇಬೇಕು. ಪ್ರೊಫೆಸರ್ ಹೇಳಿದಾಗೆ ನಾನು ನೆಗೋಷಿಯೇಟ್ ಮಾಡಿಲ್ಲ ಅಂತಾದರೆ ಅನ್ಫೇರ್ ಲೇಬರ್ ಪ್ರಾಕ್ಟೀಸ್ ಎರಡು ಕಡೆಯಿಂದನೂ ಪೆನಾಲ್ಟಿ ಭಾಳ ಜಾಸ್ತಿ ಆಗಿದೆ. ಎಂಪ್ಲಾಯರ್ ಮಾಡಿಲ್ಲ, ಒಂದು ಸಲ ಮಾಡಿಲ್ಲ, ಮತ್ತೆ ಸಲ ಮಾಡಲಿಲ್ಲ, ಅಗೇನ್ ಸೆಕೆಂಡ್ ಟೈಮ್ ಪೆನಾಲ್ಟಿ ಜಾಸ್ತಿ ಆಗುತ್ತೆ. ಪ್ರಾಸಿಕ್ಯೂಷನ್ಗೂ ಸಹ ಪ್ರೊವಿಷನ್ ಇದೆ. ಸೊ ಯೂನಿಯನ್ಸ್ ಮಸ್ಟ್ ಬಿ ಹ್ಯಾಪಿ. ಕಂಪೇರ್ ಟು ಕರೆಂಟ್ ಸಿಸ್ಟಮ್, ಎಂಪ್ಲಾಯರ್ಸ್ ಆರ್ ರಿಕ್ವೈರ್ಡ್ ಟು ರೆಕಗ್ನೈಸ್ ದಿ ಯೂನಿಯನ್ ಆಸ್ ಲಾಂಗ್ ಆಸ್ ಒನ್ ಯೂನಿಯನ್ ಇಸ್ ದೇರ್ ಆ್ಯಂಡ್ ಯು ಆರ್ ಹ್ಯಾವಿಂಗ್ 30% ಮೆಂಬರ್ಸ್. Now you can ask me, sir, ಒಂದು ಯೂನಿಯನ್ ಇಲ್ಲ, 2 ಯೂನಿಯನ್ ಇದ್ದರೆ? There is a need of the hour. According to me, we should not have multiplicity of the unions. Now professor will tell us, employers may try to split the unions. That I will not comment. Law cannot help that. But if you are not having one union having majority, many times there is a split between 2 unions. ಐಡಿಯಾಲಜಿಗೆ ಇಂಡಿಯಾದಲ್ಲಿ ಏನಾಗಿದೆ, ಟ್ರೇಡ್ ಯೂನಿಯನ್ಸ್ಗಳು BMS ಇದೆ, HMS ಇದೆ, CITU ಇದೆ, AITUC ಇದೆ. ಟ್ರೇಡ್ ಯೂನಿಯನ್ಗಳು ವಿತ್ ಸೆನ್ಸ್ ಆಫ್ ರೆಸ್ಪಾನ್ಸಿಬಿಲಿಟಿ ಹೇಳ್ತೀನಿ, ಆ ಟ್ರೇಡ್ ಯೂನಿಯನ್ಗಳ ಫಿಲಾಸಫಿಯ ಮೇಲೆ ಅವರ ಫಂಕ್ಷನ್ ಡಿಪೆಂಡ್ ಆಗುತ್ತೆ. ಇಂಡಿಯಾದಲ್ಲಿ ಥಿಂಕ್ ಮಾಡಿ ನಾನು ಹೇಳ್ತಾ ಇರೋದು, ಯಾವ ಟ್ರೇಡ್ ಯೂನಿಯನ್ಸ್ಗಳು ಇಂಡಿಪೆಂಡೆಂಟಾಗಿ ನಮ್ಮದೇ ಈ ಥರ ಫಂಕ್ಷನ್ ಮಾಡ್ತೀವಿ. ಮಂಗಳೂರಲ್ಲಿ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಭಾಳ ಕಮ್ಮಿ ಆಗಿದೆ. ನಾನು ಕಲಿತಾ ಇರಬೇಕಾದ್ರೆ ಮಂಗಳೂರಲ್ಲಿ ಸಿಕ್ಕಾಪಟ್ಟೆ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ ಇತ್ತು. ಹಾಗಾಗಿ ನಾನು ಇಂಡಸ್ಟ್ರಿಯಲ್ಲಕ್ಕೆ ಹೋಗಿದ್ದು. ಇವಾಗ ಡಿಸ್ಪ್ಯೂಟ್ಸ್ಗಳು ಕಮ್ಮಿ, ಹೆಚ್ಚಾಗಿ ಪರ್ಸ್ಯೂ ಮಾಡ್ತಾರೆ, ಡಿಸ್ಕಸ್ ಮಾಡ್ತಾರೆ, ನೆಗೋಷಿಯೇಟ್ ಮಾಡಿ ಸೆಟ್ಲ್ಮೆಂಟ್ ಮಾಡ್ತೀರಿ. ಲಿಟಿಗೇಷನ್ ಮಾಡುವ ಅಭ್ಯಾಸ ಮಂಗಳೂರಲ್ಲಿ ತುಂಬ ಕಮ್ಮಿ ಇದೆ ಇವಾಗ. ಅದು ಒಂದು ಇಟ್ ಮೇ ರೆಪ್ರೆಸೆಂಟ್ ಅವರ್ ಐಡಿಯಾಲಜಿ. ಜನರಲಿ ನಾವು ಹೆಸರು ಹೇಳಕ್ಕೆ ಹೋಗಲ್ಲ. ಕೆಲವು ಒಂದು ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ಒಂದು ಸಂಘಟನೆ ನೋಡಿದಾಗ ಲಿಟಿಗೇಷನ್ ಇಸ್ ಪಾರ್ಟ್ ಆಫ್ ದೇರ್ ಸ್ಟೈಲ್. ಎಂಪ್ಲಾಯರಿಗೆ ಬುಲ್ಡೋಸ್ ಮಾಡಲೇಬೇಕು. there are multi AITUC ಇಂದ ಬಂದಿದ್ದಾರೆ. AITUC is one of the very responsible union body. ಭಾಳ ಹೆಚ್ಚಾಗಿ ಅವರು ಇರುವಲ್ಲಿ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಪೀಸ್ ಇರುತ್ತೆ. ಸೊ therefore many times we see 2 union leaders because of their ego, they are having 2 unions. ಒಂದು ಯೂನಿಯನಲ್ಲಿ 20% ಇದ್ದಾರೆ, ಇನ್ನೊಂದು ಯೂನಿಯನಲ್ಲಿ 20% ಇದ್ದಾರೆ. ಏನು ಮಾಡಬೇಕು? ಯಾರ ಹತ್ರ ಮಾತಾಡಬೇಕು? Therefore Government of India has brought something called negotiating council. Negotiating council could be counterproductive if employers play whatever their cards, if they try to play. That is for workers to manage. But ಒಂದು ಯೂನಿಯನಿಗೆ 51%, 2 ಯೂನಿಯನ್ ಇದೆ ಅಥವಾ ಜಾಸ್ತಿ ಇದೆ, 51% ಇಂಥ ಜಾಸ್ತಿ ಮೆಂಬರ್ಶಿಪ್ ಇಲ್ಲ ಅಂತಾದರೆ ಎಂಪ್ಲಾಯರ್ ಹ್ಯಾಸ್ ಟು ಕಾನ್ಸ್ಟಿಟ್ಯೂಟ್ ಎ ನೆಗೋಷಿಯೇಟಿಂಗ್ ಕೌನ್ಸಿಲ್. ಎವ್ರಿ 20%ಗೆ ಒಬ್ಬ ರೆಪ್ರೆಸೆಂಟೇಟಿವ್ ಇರ್ತಾರೆ. ಡಿಸ್ಟ್ರಿಬ್ಯೂಟ್ ಮಾಡಿ ನೆಗೋಷಿಯೇಟಿಂಗ್ ಕೌನ್ಸಿಲ್ಗೆ ಸಹ ಪ್ರೊವಿಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. ಸೊ ದಿಸ್ ಈಸ್ ಅಬೌಟ್ ಟ್ರೇಡ್ ಯೂನಿಯನ್ಸ್. ದೇರ್ಫೋರ್ ಟ್ರೇಡ್ ಯೂನಿಯನ್ಸಿಗೆ ನೋಡಿದರೆ ಏನು ಅಂತ ದೊಡ್ಡ ನೆಗೆಟಿವ್ ಇಂಪ್ಯಾಕ್ಟ್ ಈ ಕೌಂಟಲ್ಲಿ ಇಲ್ಲ. ದಟ್ ಈಸ್ ಮೈ ಒಪಿನಿಯನ್. ಸೆಕೆಂಡ್, I think another important aspect, unions are complaining, where employers are happy, is that about strike. Workers and unions believe strike is their weapon. Strike is very, very indispensable for them to agitate their grievances. Anta one belief. Now government feels the manner in which code has been formulated, government feels strikes are not good for industry. Earlier we had public utility service anta ittu. For example, ನಿಮ್ಮ KSRTC is part of public, it is one of the public utility service. ಸ್ಟ್ರೈಕ್ ಮಾಡಬೇಕಾದ್ರೆ ಅವರು ಒಂದು ನೋಟಿಸ್ ಕೊಡಬೇಕಿತ್ತು. 42 ದಿನದ ನೋಟಿಸ್ ಕೊಟ್ಟು ಈ 42 ದಿನದ ಅಪ್ಪರ್ ಲಿಮಿಟ್ ಅದರ ಒಳಗೆ ಅವರು ಸ್ಟ್ರೈಕ್ ಮಾಡೋದಕ್ಕೆ ಅವರು ಸ್ಟ್ರೈಕ್ ನೋಟಿಸ್ ಕೊಡಬೇಕು. ಫಸ್ಟ್ 14 ಡೇಸಲ್ಲಿ ಸ್ಟ್ರೈಕ್ ಮಾಡುವಾಗ ಇರಲಿಲ್ಲ ಪಬ್ಲಿಕ್ ಯುಟಿಲಿಟಿ ಸರ್ವಿಸ್ಗಳಲ್ಲಿ. ಈ ಪಬ್ಲಿಕ್ ಯುಟಿಲಿಟಿ ಸರ್ವಿಸ್ ಬಿಟ್ಟರೆ, ಪಬ್ಲಿಕ್ ಯುಟಿಲಿಟಿ ಸರ್ವಿಸ್ ಅಂತ ಹೇಳಿದ್ರೆ ವಿಚ್ ಈಸ್ ಮೋರ್ ಆಫ್ ಎ ಪಬ್ಲಿಕ್ ಇಂಪಾರ್ಟೆನ್ಸ್. ಫಾರ್ ಎಕ್ಸಾಂಪಲ್, ಈಗ KSRTC ತಗೊಳ್ಳಿ. KSRTCಯಲ್ಲಿ ಸ್ಟ್ರೈಕ್ ಮಾಡಿದರೆ ಜನರಲ್ ಪಬ್ಲಿಕ್ಗೆ ತೊಂದರೆ ಆಗುತ್ತೆ. ಅದೇ ಥರ ಬೇರೆ ಬೇರೆ ಇಂಡಸ್ಟ್ರೀಸ್ ಸರ್ಕಾರಕ್ಕೆ ನೋಟಿಫೈ ಮಾಡುವ ಅಧಿಕಾರಸು ಕೊಟ್ಟಿದ್ರು. ನಾನು ಹೆಚ್ಚಿನ ಅದಕ್ಕೆ ಹೇಳಕ್ಕೆ ಹೋಗೋದಿಲ್ಲ. ನಾವು ಪಬ್ಲಿಕ್ ಯುಟಿಲಿಟಿ ಸರ್ವಿಸ್ ಅಂತ ಹೇಳೋ ಕಾನ್ಸೆಪ್ಟ್ ತೆಗೆದುಬಿಟ್ರು. ಹಿಂದೆ ಏನಾಗ್ತಾ ಇತ್ತು, ಬೇರೆ ಇಂಡಸ್ಟ್ರಿಗಳಲ್ಲಿ ನೋಟಿಸ್ ಕೊಡೋದೇ ಸ್ಟ್ರೈಕ್ ಮಾಡಲಿಕ್ಕೆ ಅಧಿಕಾರ ಇತ್ತು. ಇವಾಗ ಅದು ಹೋಗಿದೆ. ಎಲ್ಲ ಇಂಡಸ್ಟ್ರಿಗಳಲ್ಲೂ ನೀವು ಏನು ಮಾಡಬೇಕು, ಸ್ಟ್ರೈಕ್ ಮಾಡಬೇಕಾದ್ರೆ ಒಂದು ನೋಟಿಸ್ ಕೊಡಬೇಕು. ಅಪ್ಪರ್ ಲಿಮಿಟ್ 60 ದಿನ, ಇವತ್ತಿನ ದಿನ 60 ದಿನದ ಅಪ್ಪರ್ ಲಿಮಿಟ್ ನೋಟಿಸ್ ಕೊಟ್ಟು ನೀವು ಕೊಡ್ತೀರಿ. ಕೊಟ್ಟಾದ ನಂತರ 14 ದಿನದ ಒಳಗಡೆ ನೀವು ಸ್ಟ್ರೈಕ್ ಮಾಡುವಾಗ ಇಲ್ಲ. ಕೂಡಲೇ ಏನು ಮಾಡ್ತೀರಿ, ಕನ್ಸಿಲೇಷನ್ ಆಫೀಸರಿಗೆ ನೀವು ಹೋಗಿ ಐದರ್ ಎಂಪ್ಲಾಯರ್ ಅಥವಾ ಯೂನಿಯನ್ ಅವರು ನೀವೇ ಇಂಟಿಮೇಟ್ ಮಾಡ್ತೀರಿ. ಇಂಟಿಮೇಟ್ ಮಾಡಿ ಆದ ಕೂಡಲೇ ಕನ್ಸಿಲೇಷನ್ ಆಫೀಸರ್ ಕನ್ಸಿಲೇಷನ್ ಶುರು ಮಾಡಲೇಬೇಕು. ಶುರು ಮಾಡಿದ ಕೂಡಲೇ ನೀವು ಸ್ಟ್ರೈಕ್ ಮಾಡುವಾಗಿಲ್ಲ. ಅದರ ನಂತರ ಕನ್ಸಿಲೇಷನ್ ಮುಗ್ದಾದ ಮೇಲೆ 7 ದಿನ ಇರುತ್ತೆ. ಡ್ಯೂರಿಂಗ್ ದ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ಕನ್ಸಿಲೇಷನ್ ಆ್ಯಂಡ್ 7 ಡೇಸ್ ಆಫ್ಟರ್ ಕ್ಲೋಜರ್ ಆಫ್ ಕನ್ಸಿಲೇಷನ್ ನೀವು ಸ್ಟ್ರೈಕ್ ಮಾಡುವಾಗಿಲ್ಲ. ನಾವು ಈಗ ಯೂನಿಯನ್ ಅವ್ರು ಏನು ಹೇಳ್ತಾರೆ, ಬುದ್ಧಿವಂತ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಏನು ಮಾಡುತ್ತೆ, ಕನ್ಸಿಲೇಷನ್ ಕ್ಲೋಸ್ ಆಯಿತು, ನಿಮಗೆ 7 ಡೇಸ್ ಇದೆ, ನೀವೇ ಹೋಗಿ ಡಿಸ್ಪ್ಯೂಟ್ ರೈಸ್ ಮಾಡಿ ಇಂಡಸ್ಟ್ರಿಯಲ್ ಟ್ರೈಬ್ಯುನಲಲ್ಲಿ ಫಾರ್ ಎಕ್ಸ್ಚೇಂಜ್. ಈಗ ರೆಫರೆನ್ಸ್ ಸಿಸ್ಟಮ್ ಇಲ್ಲ. ಸೊ ಎಂಪ್ಲಾಯರ್ ಹೋಗಿ ಡಿಸ್ಪ್ಯೂಟ್ ರೈಸ್ ಮಾಡಿ. ಸೊ ಡ್ಯೂರಿಂಗ್ ದ ಪೆಂಡೆನ್ಸಿ ಆಫ್ ಎಡ್ಜುಡಿಕೇಷನ್ ಯು ಕೆನಾಟ್ ಕ್ಯಾರಿ ಎ ಸ್ಟ್ರೈಕ್. ಸೊ ಲಿಟ್ರಲಿ ಅವ್ರು ಹೇಳ್ತಾರೆ, ಮೈ ರೈಟ್ಸ್ ಟು ಕ್ಯಾರಿ ಸ್ಟ್ರೈಕ್ ಹ್ಯಾಸ್ ಬಿನ್ ಸ್ನ್ಯಾಚ್ಡ್ ಅವೇ ಅಂತ ಒನ್ ಆಫ್ ದಿ ಗ್ರೀವಿಯನ್ಸ್. ಈಗ ಇನ್ನೊಂದು ಕ್ವಶನ್ ಬರೋದು ಏನು ಅಂತ ಹೇಳಿದ್ರೆ, ಸ್ಟ್ರೈಕ್ ಬೇಕಾ? ಸ್ಟ್ರೈಕ್ ಈಸ್ ಒಂದ್ಸಲ ನಿಮಗೆ ಎಡ್ಜುಡಿಕೇಷನ್ ಮೆಕ್ಯಾನಿಸಮ್ ಇದ್ಮೇಲೆ ನೀವು ಸ್ಟ್ರೈಕ್ ಮಾಡಬೇಕಾ? ಇಟ್ ಈಸ್ ಎ ವೆರಿ ಇಂಪಾರ್ಟೆಂಟ್ ಆಸ್ಪೆಕ್ಟ್. ಸ್ಟ್ರೈಕ್ ಬೇಡ ಅಂತಾದರೆ ಎಡ್ಜುಡಿಕೇಷನ್ ಫೋರಮ್ ಕೊಡೋದು ಸಹ ಸರ್ಕಾರದ ಕೆಲಸ. ನೀವು ಯಾವಾಗ ಎಡ್ಜುಡಿಕೇಷನ್ ಫೋರಮ್ ಸರಿ ಇಲ್ಲ ಅಂತಾದರೆ ವರ್ಕರ್ಸ್ ಇನ್ನೇನು ಮಾಡಬೇಕು? ಸೊ ಹಾಗಾಗಿ ಎಡ್ಜುಡಿಕೇಷನ್ ಫೋರಮ್ ಕೊಡೋದು ಸರ್ಕಾರದ ಕೆಲಸ ಇದೆ. ಅದು ಕೊಟ್ಟರೆ ಸ್ಟ್ರೈಕ್ ಈಸ್ ಆಲ್ವೇಸ್ ಸ್ಟ್ರೈಕ್ ಆರ್ ಲಾಕ್ಔಟ್, ಐದರ್ ವೇ. ಸ್ಟ್ರೈಕ್ ಈಸ್ ಡನ್ ಬೈ ವರ್ಕರ್ಸ್, ಲಾಕ್ಔಟ್ ಈಸ್ ಡನ್ ಬೈ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ಸ್. ಸ್ಟ್ರೈಕ್ ಈಸ್ ರೆಫ್ಯೂಸಲ್ ಟು ಡೂ ದಿ ಜಾಬ್. ಕೆಲಸ ಕೊಟ್ಟರೆ 10 ಜನಕ್ಕಿಂತ ಜಾಸ್ತಿ ಜನ ಸೇರಿ ಕೆಲಸ ಮಾಡಲ್ಲ, ಇಟ್ ಈಸ್ ಸ್ಟ್ರೈಕ್. ಲಾಕ್ಔಟ್ ಅಂತ ಹೇಳಿದ್ರೆ ಎಂಪ್ಲಾಯರ್ ನಿಮಗೆ ಕೆಲಸ ಕೊಡಲ್ಲ. ಸಿಂಪಲ್ ಆಗಿ ಹೇಳಿದ್ರೆ ಅದು ಲಾಕ್ಔಟ್. ಸ್ಟ್ರೈಕ್ ಮತ್ತು ಲಾಕ್ಔಟ್ ಎರಡಕ್ಕೆ ಸಹ ಇದು ಪ್ರೊವಿಷನ್ಸ್ ಅಪ್ಲೈ ಆಗುತ್ತೆ, ನಾಟ್ ಓನ್ಲಿ ಫಾರ್ ವರ್ಕರ್ಸ್, ಇವನ್ ಫಾರ್ ಎಂಪ್ಲಾಯರ್ಸ್. ದೇರ್ಫೋರ್ ಲಾರ್ಜರ್ ಕ್ವಶನ್, ಸ್ಟ್ರೈಕ್ ಬೇಕಾ? ಸೊಸೈಟಿ, ಈಸ್ ಇಟ್ ಎ ಫಂಡಮೆಂಟಲ್ ರೈಟ್? ಓನ್ಲಿ ಐ ಆಮ್ ಪುಟ್ಟಿಂಗ್ ದಿ ಕ್ವಶನ್ಸ್. ನಾನೇನು ಉತ್ತರ ಕೊಡೋಕ್ಕೆ ನನ್ನ ಕಾಮೆಂಟ್ಸ್ ಹೇಳಕ್ಕೆ ಹೋಗಲ್ಲ. ನೀವು ಯಂಗ್ ಸ್ಟೂಡೆಂಟ್ಸ್, ಲಾ ಸ್ಟೂಡೆಂಟ್ಸ್ ಇದ್ದೀರಾ, ಯು ಶುಡ್ ಆಸ್ಕ್ ಯುವರ್ ಸೆಲ್ಫ್ ವೆದರ್ ಸ್ಟ್ರೈಕ್ ಈಸ್ ಎ ಫಂಡಮೆಂಟಲ್ ರೈಟ್, ವೆದರ್ ಯೂನಿಯನ್ಸ್ ಹ್ಯಾವ್ ರೈಟ್ಸ್ ಟು ಕ್ಯಾರಿ ಸ್ಟ್ರೈಕ್, ವೆದರ್ ಯು ಹ್ಯಾವ್ ಎ ರೈಟ್ ಟು ಫಾರ್ಮ್ ಆ್ಯನ್ ಅಸೋಸಿಯೇಷನ್ ಆಲ್ಸೋ ಇನ್ಕ್ಲೂಡ್ಸ್ ರೈಟ್ ಟು ಸ್ಟ್ರೈಕ್. ಸ್ವಲ್ಪ ಸ್ಟಡಿ ಮಾಡಿ ಮತ್ತೆ ಉತ್ತರ ನಮಗೆ ಕೇಳ್ತಾ ಇದ್ದೀನಿ. ಆಸ್ಕ್ ಯುವರ್ ಸೆಲ್ಫ್, ಗೋ ಟು ಯುವರ್ ಲೈಬ್ರರಿ, ಮೇಕ್ ಸಮ್ ರಿಸರ್ಚ್. ಬಟ್ ಎಂಡ್ ಆಫ್ ದ ಡೇ employers, if they want to run business peacefully, strike probably is the one worst thing they want to avoid. Government also, if they want to attract investments, strikes are not conducive. But having said that, workers, if they want to ventilate their grievances, there should be a proper mechanism. So there should be some good midpoint. ನಾವು ಎಡ್ಜುಡಿಕೇಷನ್ ಫೋರಮ್ಮು ಕೊಡಲ್ಲ, ಎಫೆಕ್ಟಿವ್ ಫೋರಮ್ಮು ಕೊಡೋದಿಲ್ಲ, ಸ್ಟ್ರೈಕು ಮಾಡಬೇಡಿ ಅಂತ ಹೇಳಿದ್ರೆ ತಪ್ಪಾಗುತ್ತೆ. ದೇರ್ಫೋರ್ ಸರ್ಕಾರ ಶುಡ್ ಲುಕ್ ಇನ್ ಟು ದ್ಯಾಟ್. ಐ ಪರ್ಸನಲಿ ಬಿಲೀವ್ strike is not only the solution. There are much better way of persuasion is there. Once you do a strike, end of the day worker should understand you are working for that, you are working with that employer. Employer should understand they are your workers. If there is a good relationship between harmonious employee relations, if it is there, it is a foundation. You can talk about 5S, TPM, total productive system, everything you can talk, but industrial discipline or industrial relations is the foundation without which there cannot be any peaceful business. Therefore employers and often I say ganda ಹೆಂಡತಿಯ ಗಲಾಟೆ ಹೆಂಗಿರುತ್ತೆ ಹಂಗೆ employer-employee dispute. If you try to stretch too far, if relationship tears, it will end up in divorce. So therefore employer-employee relationship, union leadersಗೆ ಬೇಕಾಗಿರೋದು ಮೆಚ್ಯೂರಿಟಿ, ಎಂಪ್ಲಾಯರ್ಸಿಗೆ ಬೇಕಾಗಿರೋದು ಮೆಚ್ಯೂರಿಟಿ. ಒಂದು ಹಂತದಲ್ಲಿ ನೀವು ಗುದ್ದಾಡಿ, ಬಟ್ ಅದು ಯಾವುದಕ್ಕೂ ಕೈ ಮೀರದಾಗೆ ನೋಡಿದರೆ ವರ್ಕರ್ಸು ಚೆನ್ನಾಗಿರ್ತಾರೆ, ಇಂಡಸ್ಟ್ರೀಸು ಚೆನ್ನಾಗಿರುತ್ತೆ. ಇಲ್ಲ ಅಂತಂದರೆ ವರ್ಕರ್ಸ್ ಲಾಯರ್ಸ್ ಚೆನ್ನಾಗಿರ್ತಾರೆ, ನಾವು ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಲಾಯರ್ಸ್ ಚೆನ್ನಾಗಿರ್ತೀವಿ. ಇಷ್ಟು ಲೈಟರ್ ನೋಟಲ್ಲಿ ಹೇಳಿ ಐ ಸಿನ್ಸಿಯರ್ಲಿ ಥ್ಯಾಂಕ್ ಮ್ಯಾನೇಜ್ಮೆಂಟ್ ಆಫ್ ವಿವೇಕಾನಂದ ಲಾ ಕಾಲೇಜ್, ಪರ್ಟಿಕ್ಯುಲರ್ಲಿ ಪ್ರೊಫೆಸರ್ Ravindra, who was my principal. Yesterday I had 8-hour session. For all reasons, I had to escape from him because of my respect to him. I said, sir, morning ho to bartini. Thank you, sir, thank you.
Thank you, sir. Through this national seminar, the message is clear. Though these reforms are a significant step in formalizing the workplace, extending social security benefits and create more efficient labor market, critically analyzing pros and cons is equally necessary to understand new labor code better. Now, I invite Dr. B.K. Ravindra, Director of Legal Studies, for his concluding remarks.
Respected resource persons, my colleagues, representatives from various organizations and law colleges, as well as my dear students. I am seeing my professor after several years. You may be surprised, how is that Babu Matthew has come here? He was my professor in the year 1969. He was teaching me botany. I still remember. There were 3 to 4 professors in St. Philomena's College in Mysore. And the principal of the college was Father Fleury, a Frenchman. I couldn't understand his English. But when we used to come to the class, I was very happy to sit and listen to the lectures of Baba Matthew and Srinadi, a physics professor. Remember, I'm not a science student. I'm an art student. History and geography and economics was my subject. But in those days, there was a subject called as general science. So in that, we have to study something of every subject, including mathematics was taught to us. Therefore, as far as Professor Baba Matthew is concerned, he was coming to teach us as a demonstrator. And the way he was delivering lectures, and he was very young and very smart, even now he is very smart. That's a different question. But he was so beautifully dressed, come to the classes and maintain the decorum and the discipline of the college in such a beautiful way. So I was aghast, and I was feeling that if I want to become something, I should become a professor. That's how I was. This teaching skills gets imbibed by looking to your professors. And similarly, Srinidhi was an excellent physics professor. I used to say in my classes to some students. So I still remember, I said in the class, Mr. Srinidhi came to the class and taught us the Boyle's law and the gravitation theory. Therefore he said, and he just when he gave his lecture, he said, the law says like this: at a constant temperature, the volume of a certain mass of gas is inversely proportional to its pressure. Arey baap re, I couldn't understand what he has said. And we were all blinking. Then he said, did you understand? No. Then, similarly, another law said, when a solid is immersed under liquid, it undergoes an apparent loss of weight which is equal to the weight of the liquid displaced. Arey baap re. Then he said, I will demonstrate. He went to the lab, brought a cup of water in glass. He brought water and a small stone also, put the stone into the glass and then started explaining. He was really awestruck. See, that is the teaching skill. And the language was so tasty that we would like to hear his language. Similarly was Professor Baba Matthew. And the brother of Srinidhi, well, he was teaching us the chemistry. There were some of the formulas, I know it very well, and I apply it whenever I need. So the students may think that is a science student. Then, you see here, at those days, even we were naughty like you fellows. There were some students in the class. So by looking at Srinidhi, who was very white, fair, always come with white dress. So students kept a name. So the younger brother is Silver Rod. So his name was not Srinidhi, they called him as Silver Rod. As his brother was little black, therefore called him as Carbon Rod. So you Carbon Rod class idyo, you Silver Rod class idyo, hogra class ge. See, this is how. So this sort of a mimicry was there, but when we come to the class, we were taken away by all the teachers. Similarly, we had Mr. Krishna Rao, who was teaching language English and Ekambaram. Ramdas was there. So still I remember. And you know, even at that in the year 1969, the principal used to conduct an interview to take us to the classes. Even though I studied in PUC in St. Francis College, to get a degree, to get into the degree class, he was interviewing us. Then somehow I passed PUC, PCMB. Then I came to the degree. So for first year BSc admission, I went to the Father Flurry. He spoke, he asked certain questions. I couldn't answer because I couldn't understand what he is saying. Then ultimately he said, what do you want to become? What do you want to become? I said, doctor. He said, he will not even become a compounder. Go. Then I said, how is that? Then what I will become? He just laughed and said, you are going to become a professor. Go. See, this is how. See, when we came to then no other alternative. When he did not give me the BSc, then I had to go for BA. And I had very good professors. We had a wonderful history professor, geography professor, and economics professor. I should always remember them. Therefore, we had such teachers. One such teacher is, well, Mr. Baba Matthew. Baba Matthew said, see, I don't have a degree, doctorate, not necessary, sir. Not necessary. Don't think that persons who are having 3 to 4 degrees, I have seen in my career as a teacher from last 48 years, that some of the teachers with all degrees, they don't know how to teach. They will be massacred by the students, I have seen. And the knowledge is very poor. But even in those days, and same tempo is maintaining even now, it is not the quantity that matters, that is the quality that matters. Therefore, as Baba Matthew is concerned, you may agree or disagree. I always term my professor as a scholar. All my professors whom I name, in law we had Professor C.K. Raja, we had Ananta Krishna, we had Ram Rao. So here we had T. Devidas, we had V. Nagaraj. See, all beautiful professors we had. If I am wrong, my professor will correct it because he has taught in all those colleges. He knows pretty well. Therefore, I still remember the case because we knew the quality of professors. Therefore, I always look at them from that perspective. Now I was eager. When he accepted my invitation, I was so happy. I told my management also, you get a very good resource person. Similarly, coming to the Mr. Johnson, I need not speak about Johnson. By looking at him, the way he makes presentation, come to understand, a very humble man. Very humble. Very soft. I had not seen him scolding any student in the 𝐻𝐵 Law College. Students were very happy. His teaching was excellent. See, this is, I find, rare petals here in a teaching category. He may call me as a critic. I'm not bothered. I tell you the truth. Therefore, he was an excellent teacher, very humble, and very regular to the class, and keeping in the class timings. So if you name me in everything, I can give him 100%. And I was happy to be associated with him, because from Sullia he came to 𝐻𝐵 Law College. I had the report, and I told the management, this candidate, you can appoint him directly without any interview. And he was selected. Ultimately, God has placed him in a very good position now, because the government wanted his services. That was written on his fate. Then he came to the labor side. Today you might have understood what sort of gentleman he is. Similarly, Mr. Prashant, when I spoke to him over phone, after several years I was speaking to him, sir, yes sir, sir, the way he spoke, busy, I know he is very busy. ನಾನು ಮಾತಾಡ್ಕೊಂಡೆ ಸಿಗ್ತಾರೋ ಇಲ್ವಂತ, ಸರ್ ನೀವು ಹೇಳೋದು ಸಿಗ್ತಾರೆ. ಸೊ ಮರ್ಯಾದೆ ಸ್ವಲ್ಪ ಉಳಿಸ್ಕೊಂಡಿದ್ದೀನಿ ಅಂತ ಅನಿಸ್ತದೆ ನನಗೆ, ಸ್ವಲ್ಪ ಮರ್ಯಾದೆ ಉಳಿದಿದೆ ಅಂತ. Therefore, you find it's a very, see, this is what we have not made, teachers cannot make money, but at least they can maintain the reputation. If at the fag end of my life, I don't want to say lies, because when you are there in the teaching profession, we should not become politicians. We should not just go on speaking some nonsense, speaking of high values without maintaining values in the profession. Then people will not tolerate you. You are sending a wrong message. Therefore, thank God, Prashant, and there are some more friends of mine who are there in the High Court, including Michael D. Kunna, Justice Abdul Nazir. See, I have very good persons in the High Court, and as well as the Supreme Court. See, these are all the petals to me. Their value cannot be assessed so easily. Even Prashant, in his profession, he has maintained that the dignity and decorum. No one can speak ill of him. I have seen, because teachers go ಕೆಟ್ಟ ಬುದ್ಧಿ ಇದೆ. ಯಾರು ಅವ್ನು ಹೇಗೆ ಅಂತ, ಅವ್ನು ಹೇಗೆ, ನಿನ್ಗೆ ಯಾಕೆ, ನೀನು ಹೇಗೆ ಅಂತ ಕೇಳಬೇಕು ನಾವು ಅವರು. ಅದೊಂದು ಚಟ ಇರ್ತದೆ. ಆದರೆ ಸಾಧಾರಣವಾಗಿ ಸರ್ ಅವ್ರ ಬಾರಿ ನಾನು ಕೇಳಿದ್ದು, ಕೆಲವರು ಉಳಿಸ್ಕೊಡದೆ ಇರ್ಬೋದು, ಆ ಪ್ರಶ್ನೆ ಬೇರೆ. ಬಟ್ thank God, I should appreciate God that all my students who are there from several years, from last 40 years, most of them are in a very good position. And it's a blessing for me given by God. The last but not the least is Rashmi Shetty. She's a wonderful lady. ಇಷ್ಟು ಒಳ್ಳೆ ಹುಡುಗಿ, ಇಷ್ಟು ಒಳ್ಳೆ ಹೆಂಗಸು ನಾನು ನೋಡೇ ಇಲ್ಲ. ಎಷ್ಟು ಹಂಬಲ್, ಎಷ್ಟು ಪೊಲೈಟ್ ಅಂದರೆ ಫ್ರಮ್ ಸ್ಟೂಡೆಂಟ್ ಡೇಸ್, ಈಗಲ್ಲ ಅವಾಗಿಂದ ನೋಡ್ತಾ ಇದೆ ಸರ್. ಮಾತಾಡ್ದಕ್ಕೊಳ್ಳಿ, ಟೈಮ್ ಸೆನ್ಸ್ ಹಾಕ್ಕೊಳ್ಳಿ, ಎಷ್ಟು ಇದು ಮಾಡ್ತಾಳೆ ಅಂದರೆ, ನಾನು ಈಗ ಸರ್ ತಲೆ ಕೆಡಿಸ್ಕೊಬೇಡಿ ವರ್ಕ್ಶಾಪ್ ಬಗ್ಗೆ, ನಾನೆಲ್ಲ ಮಾಡ್ತೀನಿ ಸರ್, ನೀವು ಸುಮ್ಮನೆ ಎಲ್ಲ ಮಾಡಿ ನಾನು ನಿಮಗೆ ಅಟ್ಯಾಚ್ಮೆಂಟ್ ಕಳಿಸ್ಬಿಡ್ತೀನಿ, ನೀವು ಸುಮ್ಮನೆ ಇರಿ ಸರ್, ಆರಾಮಾಗಿರಿ ಅಂತ. ಯಾವ ಫೋನ್ ಮಾಡಿದ್ರೆ ಇಮ್ಮಿಡಿಯೇಟಾಗಿ ಉತ್ತರ ಕೊಡ್ತಿಲ್ಲೋ, ಬೇಕಾದಷ್ಟು ನನಗೆ ಸಹಾಯ ಮಾಡಿದ್ದಾಳೆ. ಇದಕ್ಕೆ ಈ ವರ್ಕ್ಶಾಪಿಗೆ ಅವಳು ಬೇಕಾದಷ್ಟು ಸಹಾಯ ಮಾಡಿದ್ದಾಳೆ. ಆದರೆ ನನಗೆ ರಶ್ಮಿ ಶೆಟ್ಟಿಯಾಗ ಆವಾಗ ನೆನಪಾಗ್ತದೆ, ಇಷ್ಟು ಸಹಾಯ ಮಾಡ್ತಾಳೆ ಮಕ್ಕಳು ಅಂತ. ಇಷ್ಟು ಸಹಾಯ ಮಾಡ್ತಾಳೆ, ನಮ್ಮ ಮಕ್ಕಳು ನಮ್ಗೆ ಸಹಾಯ ಮಾಡಲ್ಲ. ಹಾಗೆ ದೇವ್ರ ಹತ್ರ ದೇವ್ರಿಗೆ ಬೈದೆ, ಅಯ್ಯೋ ದೇವರೇ, ನನಗೆ ಮಗ ಕೊಡೋ ಬದಲು ಈ ಮಗಳನ್ನ ನಂಗೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ರೆ ರಾಜ ಆಗಿಬಿಡ್ತಿದ್ದೆ ನಾವು ಅಂತಂದೆ, ರಾಜ ಆಗಿಬಿಡ್ತಿದ್ದೆ ಅಂತ. ದೇರ್ಫೋರ್ ರಿಮೆಂಬರ್, these are all the things. I am a man who is speak directly. So thank God my teachers, my students have so much amount of affection towards me, and I tell the name of the last person whom I have to remember. I remember his name wherever I go. See, I have started visiting my professors one by one from last 10 years. Prior to that, I was not going. You may ask me a question, why, sir? I was with Abdul Kalam, Dr. Abdul Kalam, in Dharmasthala for 3 days. One day he called me, Ravindra, come here. ಅವ್ರಿಗೆ ಪ್ರೆಸಿಡೆಂಟ್ ಅವ್ರಿಗೆಲ್ಲ ಬಿಕ್ಕಾಬಿಟ್ಟೆ ಪ್ರೊಟೆಕ್ಷನ್ ಇರ್ತದೆ. ಆದರೆ ನನಗೆ 3 ದಿವಸ ಅವರಿದ್ದಾಗ ಅವ್ರಿಗೆಲ್ಲ ಗೊತ್ತಾಗಿದೆ, ಹೋಗಿ ಹೋಗಿ ಸರ್ ಕರಿತಾ ಇದ್ದಾರೆ ಅಂತ. ಐ ವಾಂಟ್ ಟು ಆಸ್ಕ್ ಒನ್ ಕ್ವಶನ್ಸ್ ವಿತ್ ಯು. ಅವರು ಮಾತಾಡೋದು ಒಳ್ಳೆ ನಮ್ಮ ಜಾನ್ಸನ್ ಮಾತಾಡಿದಾಗೆ. ಐ ವಾಂಟ್ ಟು ಆಸ್ಕ್ ಯು ಒನ್ ಕ್ವಶನ್. ಟೆಲ್ ಮಿ ಸರ್, ನೀವು ಇಷ್ಟೆಲ್ಲ ಓದಿದಿರಲ್ಲ, ಓದಿದ ಮೇಲೆ ನಿಮ್ಮ ಟೀಚರ್ಸ್ ಎಲ್ಲ ನೆನಪಿದೆಯಾ ಸರ್? ನೆನೆಸ್ಕೊಳ್ತೀರಾ? ನೆನೆಸ್ಕೊಳ್ತೀನಿ. ವರ್ಷಕ್ಕೆ ಒಂದು ಸತಿ ಏನೋ ಅವ್ರ ಮನೆಗೆ ಹೋಗ್ತೀರಾ? ಇಲ್ಲ ಸರ್. ತಪ್ಪು ಮಾಡ್ತಿದ್ಯಾ ನೀನು. ಯು ಹ್ಯಾವ್ ಟು ನಾಟ್ ಟು ಜಸ್ಟ್ ರಿಮೆಂಬರ್, ಗೋ ಟು ಸಿ ಹೌ ದೇ ಆರ್. ಇಟ್ಸ್ ಅ ಡ್ಯೂಟಿ. ಇದು ನೀ ಕೊಡೋ ದಕ್ಷಿಣೆ. ಅದು ಹೇಳಿರ್ತಾರೆ. ನೆಕ್ಸ್ಟ್ ವೀಕೆ ನಾವು ಓಡೋದೆ ಸಿ.ಕೆ.ಎನ್. ರಾಜ್ ಮನೆಗೆ. ಸಿ.ಕೆ.ಎನ್. ರಾಜ್ ಮನೆಗೆ ಹೋಗಿ ಫಸ್ಟ್ ಅಡ್ಡಿಬಿದ್ದೆ, ಸಾರಿ ಸರ್ ಅಂತ. ಆಮೇಲೆ ಅವ್ರು ಕೂಸಿ ಮಾತಾಡಿ ಕಾಫಿ ಎಲ್ಲ ಕೊಟ್ಟು ಮತ್ತು ಅವ್ರು ಹೇಳಿದ್ರು, ರವೀಂದ್ರ, ನಾನು ನಿಮ್ಮ ಮನೆಗೆ ಬಂದು ನಿಮ್ಮ ಜೊತೆಲಿ ಇರಬೇಕು ಅಂತ. ಬನ್ನಿ ಸರ್, ಕಾರಿದೆ, ಬನ್ನಿ, ಕರ್ಕೊಂಡು ಹೋಗ್ತೀನಿ ಅಂತ. ನನಗೆ ವಾಕಿಂಗ್ ಸ್ಟೇ ಅದು ಕೊಡಿ, ಇದನ್ನು ಕೊಡಿ, ನಾನು ಇದು ಕೊಡ್ತೀನಿ, ವಾಕಿಂಗ್ ಸ್ಟೇ ಕರ್ಕೊಂಡು ಹೋಗ್ತೀನಿ ಅಂತ. ಇಲ್ಲ, ನನ್ನ ಹೆಂಡತಿ ಹುಷಾರಿಲ್ಲ, ನನ್ನ ಮಗ ಬರಲಿ, ನಾನು ಬರ್ತೀನಿ ನಿಮ್ಮ ಮನೆಗೆ, ನಾನು ನಿಮ್ಮ ಜೊತೆಲಿ 1 ತಿಂಗಳು ಇರ್ತೀನಿ ಅಂತ. ನಂಗೆ ಭಾರಿ ಖುಷಿಯಾಗೋಯ್ತು. ಮತ್ತು ಇನ್ನೊಂದು ಸತಿ ನಾನು ಫೋನ್ ಮಾಡೋಕ್ಕೆ ಹೋದಾಗ ಅವರ ಸಿ.ಕೆ.ಎನ್. ರಾಜ ಫೋನ್ ಎತ್ಕೊಂಡಿಲ್ಲ, ಅವ್ರ ಮಗ ಫೋನ್ ಎತ್ಕೊಂಡ್ರು, ಅಪ್ಪ ಇಲ್ಲ, ತೀರೋದ್ರು ಅಂತ. ಸೊ ಸರ್ಪ್ರೈಸ್ ನೋಡಿ. ಜೀವಂತ ಇರುವಾಗ ನಾವು ನೋಡೋಕ್ಕಾಗಲ್ಲ, ಹೋದ ಮೇಲೆ ಎಷ್ಟು ಮಾಡೋರು ಏನು ಪ್ರಯೋಜನ? ದೇರ್ಫೋರ್ ರಿಮೆಂಬರ್ ವಾಟ್ ಎವರ್ Professor Baba Matthew has said, I have all respects to you, sir. The same rapport, the same, I mean to say, the knowledge, the ocean of knowledge which you possess, you have disseminated before our audience so beautifully, and we remember you whenever we are in need of you, the Prashant or Professor Baba Matthew or Johnson. We request you kindly come out to the college and share your thoughts and convictions before us. On other occasions, whenever we require, we are going to call you. But we bow down our head to you, all the 3 of you, including Rashmi Shetty, because your cooperation, that will always be remembered in this institution. Thank you very much.
Thank you, sir. As a token of gratitude and respect, I request Dr. B.K. Ravindra, Director of Legal Studies, to hand over mementos to the dignitaries. To Dr. Babu Matthew, Professor Emeritus, NLSIU, Bangalore. To Sir K.G. Johnson, Deputy Labour Commissioner, Bangalore. B.K. Advocate, High Court of Karnataka, Bangalore, and CCI Legal Firm, Bangalore. And to Dr. Rashmi Shetty, NLSIU, Bangalore.
ಒಂದೇ ಒಂದು ವಿಷಯ ಹೇಳ್ತೀನಿ. I have seen 2 living gods of law in my life. I studied at SDM Law College. For me, Ravindra sir was God of Constitution. So we were, there's one more classmate of mine. I was in A section and he was in B section. We both were shuttle players, but we always competed that who will get highest marks in Constitution law. Unfortunately, in half marks, he was always first. But till today, I admire Ravindra sir for his, commitment and hard work. Dina professionalism and our maintain ಮಾಡಿ ಮಕ್ಕಳಿಗೆ ಇನ್ಸ್ಪೈರ್ ಮಾಡಿದ್ದು. ಥ್ಯಾಂಕ್ ಯು ಸರ್. and I am now legally adopted daughter of Ravindra sir. So second is I did my LLM from National Law School. Yet another living God I saw was Professor Babu Matthew. Thank you so much sir. ನಾವು ಚಿಕ್ಕೂರಿಂದ ಬಂದಾಗ ನಮಗೆ ಇಂಗ್ಲೀಷ್ ಮೀಡಿಯಮಲ್ಲಿ ಕಲ್ತ್ರೂ ಇಂಗ್ಲೀಷ್ ಮಾತಾಡಲಿಕ್ಕೆ ಅಷ್ಟು ಬರ್ತಾ ಇರಲಿಲ್ಲ. ಸೊ ವೆನ್ ಐ ಜಾಯಿನ್ ನ್ಯಾಷನಲ್ ಲಾ ಸ್ಕೂಲ್ ಐ ಕೇಮ್ ಫ್ರಮ್ ಎ ವೆರಿ ಸ್ಮಾಲ್ ಟೌನ್. ಐ ವೆಂಟ್ ಆ್ಯಂಡ್ ಟೋಲ್ಡ್ ಹಿಮ್, ಐ ಗಾಟ್ ವೆರಿ ಜಿಟರಿ. ಐ ಟೋಲ್ಡ್ ಸರ್ ಆಫ್ಟರ್ 1 week, ಸರ್ ಐ ಡೋಂಟ್ ಬಿಲಾಂಗ್ ಹಿಯರ್, ನನಗೆ ಇಂಗ್ಲೀಷ್ ಮಾತಾಡಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. ಸೊ ಒನ್ ಸಿಂಪಲ್ ಕ್ವಶನ್ ಹಿ ಆಸ್ಕ್ಡ್ ಮೀ, ಆರ್ ಯು ಡೂಯಿಂಗ್ ಲಿಟ್ರೇಚರ್, ಇಂಗ್ಲೀಷ್ ಲಿಟ್ರೇಚರ್ ಆರ್ law? I told law. So law ಅಲ್ಲಿ ಸತ್ವ ಇಂಪಾರ್ಟೆಂಟು, ಇಂಗ್ಲೀಷ್ ಮಾತಾಡೋದಲ್ಲ, ಯು ರೀಡ್ ಒನ್ ಬುಕ್ ಅಂತ ಹೇಳಿದರು ಸರ್, ಡೇಲ್ ಕಾರ್ನೆಗಿ. ಸೊ that is how I started learning, and I just completed my PhD. I'm not yet a doctor, so there is a correction there. I'm waiting for my result. He's also a living God, and we are all blessed to have teachers like them. Thank you.
Thank you, ma'am. May I now request my colleague Srimati Subhashini J to render a vote of thanks.
A very good afternoon to one and all. It is my privilege to extend the vote of thanks on behalf of Vivekananda Law College. First and foremost, I express our deep gratitude to Dr. Babu Matthew, Professor Emeritus, National Law School of India, University Mangaluru, for gracing this occasion with your presence and for your insightful and thought-provoking address. Thank you, sir. Our sincere thanks to Shri �KG Johnson, Deputy Labour Commissioner, Mangaluru, for accepting our invitation and for sharing his valuable perspectives. Thank you, sir. We extend our heartfelt thanks to Shri Prashant BK, Advocate, High Court of Karnataka and CCI Legal, Mangaluru, for adding such a great value to this event. Thank you, sir. A special note of thanks to Dr. Rashmi Shetty, National Law School of India, University Mangaluru, for her gracious presence. Thank you, ma'am. We are grateful to Dr. B.K. Ravindra, Director of Legal Studies, Vivekananda Law College, for his continuous guidance and support. Thank you, sir.
ಸುದ್ದಿ ಚಾನಲ್, ಕ್ಷಣ ಕ್ಷಣದ ಸುದ್ದಿಗಾಗಿ.